International Corporate Personhood, Business and the Bodyless in International Law by Kevin Crowe, published by Routledge in 2021. This is an extended summary of the book's argument, from the birth of the corporate person to a theory of what international law should do with it. Crowe's subject is the international corporate person, the ICP, a trans-border legal personality holding an expanding arsenal of rights that belong exclusively to it and generating private rules that increasingly govern everyone else. It is a person composed of persons, fluid in form and in ownership, transcending states yet receiving its legal form from them. It overlaps at times with the individual, at times with the state, and accrues rights available to neither. 5 vignettes open the book. In Urbaser versus Argentina, a tribunal read a human right to water into Argentina's obligations, but found the corporation contracted to deliver it under no duty to do so. Exxon met climate investigations with civil rights lawsuits, claiming a political right to silence. JHO laundered over $1 billion through slapdash offshore shells. Apple used polished versions of the same technologies, including Irish subsidiaries that elected statelessness, to keep $250 billion beyond any tax collector's reach. And Airbus bought its way out of prosecution with a €3.6 billion deferred prosecution agreement, an immunity only legal persons can purchase. The history begins with a trinity: state, church, and company, law's 3 great bodies without bodies. Long before the modern firm, these were the institutions law learned to treat as persons, entities that outlive their members, own property, and act through agents. Corporate personhood then develops in 3 phases. In the magistrate charter phase, before 1850, incorporation was a sovereign grant, a privilege given for a purpose. In the public charter phase, from 1850 to 1945, general incorporation laws spread, and the corporation became an ordinary tool of commerce. And in the personhood phase after 1945, a concept forged in American constitutional law went international, animated by tribunals and treaties in an era of interdependent globalization. How have theorists placed this creature? 3 ways: as a pair individual, a big person; as a pair estate, a small sovereign; or as a pair institution, an organ of the international order. And 3 theories explain why it exists at all: the organic or real entity theory, the positivist concession theory, and the proxy or institutional theory. The book's contention is simple: each captures something, and none captures the ICP. One structural fact matters throughout: the separation of ownership and control. Shareholders do not own the corporation in any classic sense. They hold intangible rights to dividends and to votes, and their liability is not so much limited as absent. Most shares are bought from other shareholders, not from the company, so the intuition that buying stock funds the firm is usually false. Chapter 2 maps the ICP across the world's courtrooms. Investment tribunals recognize its subjectivity and substantive rights. The Alien Tort Statute tested its liability before American courts curtailed it. Human rights, environmental, and intellectual property cases fill in the picture, and the New York Convention quietly imports rights across borders. The chapter closes by sorting these judge-made obligations into duties owed erga omnes, toward all, and jus cogens, the norms from which no one may derogate. Chapter 3 turns to the treaty shelf. Business and human rights frameworks, from the European Convention to Ruggie's Protect, Respect, and Remedy, engage the ICP gently. Anti-corruption instruments, transfer pricing rules, tax haven practice, and deferred prosecution agreements engage it lucratively. Environmental texts from Stockholm to Rio, and economic instruments from the ruins of the new international economic order to the OECD guidelines complete the corpus. Then comes the crucial twist: the ICP does not merely receive this law, it authors it. Corporate interests hold consultant and observer status inside UN processes. The WTO's TRIPS agreement was drafted to the specifications of a corporate lobby, and CEO preferences travel into treaty positions through political spending. The ICP is a constituent of the very legal order that claims to govern it. The descriptive half culminates in the book's core finding: 22 judge-made and text-made rights and privileges available to the ICP and to no other international legal personality. They sort into two categories. Active rights are substantive and shapeable through the ICP's own agency, the right to sue sovereigns, to set intra-firm prices, to lobby. Passive rights are procedural, the ICP as a legal platform to which possibilities can be assigned. The normative half begins by refusing analogy. The ICP, Crow writes, is not cleanly analogous to anything. He adopts Philip Jessup's transnational method instead, begin from human problems, not from legal categories. Two such problems organize the theory. Constituency, whom does international economic law actually serve? And sovereignty, which ICPs deploy as a strategy, invoked when useful, dissolved when not. A chapter on the public-private delusion shows, through insurance and state-owned enterprises, how the line every argument relies upon dissolves under inspection. The theory itself draws on Hume and Hofeld, understand the ICP as a bundle of sticks. It is not animated by any single family of rights, but by a bundle limited liability, cross-border contract, suing sovereigns, political speech, each stick separable, each assignable. From there, the prescription, grant the passive sticks for problems that are genuinely universal, withhold universalized active sticks, which the ICP shapes through its own agency. And where new sticks accrue deferred prosecutions, layered taxation, transfer pricing, direct liability should follow without the shield of the veil. The final chapter widens the lens to political bodies and the bodyless. The ICP disperses into global value chains and dresses itself in corporate social responsibility. Meanwhile, nature, animals, and artificial intelligence wait at law's door, things that might yet become persons. The reform menu is concrete: new regimes for human rights and environment, global taxation and wealth registration, and structural governance, codetermination, collective decision-making, and Keiretsu-style cross-holding. The conclusion names the status quo: corporate sovereignty as sword, state sovereignty as shield. The more powerful the ICP, the more freely it shifts between public and private to escape liability. Crow's proposal: tort law should address obligations, criminal law should address aspirations, and neither sovereignty nor veil should stand between human problems and their resolution. Because the ICP remains the most flexible and adaptive personality in international law, finely suited and underutilized to realize radical change in environmental protection and the distribution of wealth. International Corporate Personhood, Business and the Bodyless in International Law. Kevin Crow, Routledge, 2021.